Thanks very much, David, for that introduction, and won't touch the microphone ever again. It's a real pleasure to be here. It's great to be back at the Gold Coast. I'm actually a Queenslander originally. I actually grew up, Uncle John mentioned Teviot Brook. I actually grew up not far from there, so it was fun to remember my roots and know where I come from. And I actually started off working in Brisbane in the courts, and people often say to me, well, how did you segue from being a lawyer into technology? And this was back in the early 90s, and in the courts there was one computer in the library that had one of those old modems with the AT&T string, make those funny sounds, connect, and I was the only person who seemed to be able to turn it on, work it, and get email. So not very technical, I know, but back in the day that seemed to be very technical for lawyers in the courts at the time. Okay, so I'm just, I don't know what's happening with that. Just a quick overview. I'll just mention some terms. Maybe I should have the... okay. If those of you online, if you could perhaps mute, everyone could mute for those who are connecting remotely. That might just stop some of the feedback. Is that better? That seemed to be better. Thank you, whoever that was. Okay, just a quick overview. I'll just mention some terms. I'm not sure, there's some of you in the audience who are very knowledgeable in this area, quite sophisticated users. There's some that, some of these terms might be new or you don't really understand them. I'll also look at how courts are treating things like crypto assets, and there's quite a lot happening in the law at the moment, and it's quite refreshing to see courts embracing this. Some of the old law is actually being used to apply it to some of the new technology, and I'll talk a bit about that. Look at crypto assets as evidence. So obviously my interest and expertise is in digital evidence and how that is prepared, making sure you've got your chain of custody, how you prepare and present it in court, and whether there's any issues, particularly in relation to authentication once you do get to court. Also, an interesting point is intellectual property. So things like NFTs, non-fungible tokens, ownership. There's again a whole host of legal issues that come to the fore there. Talk briefly about the metaverse and regulation of AI. So just some terms. Crypto assets are obviously an asset that lives digitally, and the courts, and there's a Law Commission report which I'll talk about in England which has looked at this in some detail. Things like blockchain, understanding the blockchain and how that technology works, because that is the technology upon which cryptocurrency is based. And being able to use the blockchain to authenticate using the cryptography around that in order to make sure that the transactions are authenticated. Non-fungible tokens, which are essentially, fungibility goes to whether it can be replaced or not. So for example, fiat currency, so if you have a dollar, that is fungible because it can be replaced with another dollar. The concept of non-fungible is that it is unique. Looking at smart contracts, I think the basic, what we think of as a digital contract is probably not that smart. It's pretty much just a basic program, if, when, then statement. But I think looking at some of the technology we've seen today, where you could potentially have quite a complex contract to tie into what they call a smart contract, which sits on the blockchain and works in tangent with something like an NFT, is probably where we're going. And then, of course, the metaverse. I'll just touch on this. That's, I guess, around the corner. It's something that's quite topical at the moment. There's a lot of tech that probably needs to get up to speed before we get there, but it will raise and is already raising some legal issues which commentators are already commenting on at the moment. So how do courts treat crypto assets? We've actually got some case law now where this has actually been considered. And probably the most seminal case for us is a New Zealand High Court case back in 2020 of Rusco and Cryptopia. Cryptopia was a digital currency exchange who went bust. They had a hack, lost a lot of money, and then the liquidators needed to know how that was classed. Is it classed as property, which they could then get their hands on, and was it held in trust? That was a secondary issue. There's also an English case of AAA against persons unknown. The English courts are very happy to make orders against unknown people, and I'll talk a bit about that. So just looking at the English case, I quite like that case because the judge there looked at this issue in some detail, and the judgment's really good. I thought for a lawyer, the judge really got his head around cryptocurrency and the technology behind it. He got his head around it really quickly and well, and the explanation that he had in the judgment was quite clear. He looked at an old case, I haven't put it there, it's Colonial Bank against Winnie, which is I should mention, an old case which looked at things in possessions or things in action. Back when I was at law school, we called it choses in possession or choses in action. I'll talk a bit more about that in a moment because that's based on some very old English law. But in terms of exactly what is property, the court in this case looked at a 1965 English case which set out 4 principles in terms of what comprises property. And you can see them there. It's got to be definable. That means it's isolated from other assets. It's identifiable by third parties. It can capable in its nature of assumption by third parties, and it has some degree of permanence and stability. So how does this then relate to crypto assets? And the judge actually made some quite pertinent analogies. So for example, he said, well, we've got crypto being definable, and he gave an example of bank accounts that we have now. So notwithstanding they're held on computer networks, they still belong to us. There's a ledger in a bank account somewhere, for example. So that analogy was drawn to say, well, crypto assets are the same thing. It's identifiable. So for example, with our bank accounts, we have a PIN to access those. He likened that to the private public key cryptography that we use for crypto assets. And he said, well, there's no doubt cryptocurrencies can and are the subject of trading markets, so that ties into an assumption by third parties with respect to property and ownership. And the use of the blockchain demonstrates that crypto assets have some semblance of permanence and stability. Okay, so quite clear. So, very clear indication there that the law is keeping up. Really interesting in England. So 3 years ago, which in today's terms is not that long ago, but could be 150 years when we're talking about the current tech, this whole issue of shows in possession versus shows in action were first considered. About a month ago, the Law Commission in England just released its digital assets consultation paper, and they went into this question a lot more deeply. They reviewed some of the old cases. There's a case I mentioned earlier back in 1886, so about 136 years ago, of Colonial Bank against Winnie, which essentially said we've got 2 types of things. One is a thing in possession or a shows in possession where you can touch it, feel it. So this would be something in possession, or a shows in action. So it's an intangible form. You've got to have some right to bring an action in order to recover whatever you're entitled to. Essentially what the Law Commission has said is that, well, that's 136 years old. What happened back then doesn't really keep up with what we're trying to do now. So we actually think we need to have a third category, and they've called it data objects or data assets. So obviously we don't have a court case yet to say that, and we don't have any legislation to say that, but we've got a bunch of very bright people who've put this together. They actually went out to, they put a consultation paper out and got a lot of feedback from the profession, industry, and everybody said, well, yes, this is a bit of a no-brainer. We do need to have this third category. I should mention that data objects, data assets are different to what they're calling information. There's, again, some court cases which talk about, is it a thing? Is it capable of being possessed? Is it tangible, intangible? Or is it just information? And what I mean by that is, if I tell you something, I don't know, a secret, and I pass that information from me to you, does that necessarily give you any rights, or me any rights, or entitlement to that information? Probably not. But if there is a certain legal right attaching to that information, well, the law already deals with that anyway. So we've got laws of confidentiality. So if you sign an NDA, we'll give you some information, you can't disclose it, and you do, you'll get sued. We already have laws protecting intellectual property. Now, I think that probably does have some crossover, but certainly with respect to intangible property, we do have a wealth of legal precedent there already, and some legislation. And then, of course, we've got data privacy legislation. There is potentially also some common law rights. There's a tort of invasion of data privacy, which was actually put to the fore here in the District Court in Brisbane by Judge Skane a little while ago. And with the new data privacy laws that are being considered, that may actually be put into legislation. So we've got adequate laws, I think, to cover some of the tech that we're dealing with. Of course, governments are now thinking, well, this crypto stuff, how do we get in how do we get in there? I think the tax office can already ping you for capital gains tax if you make a capital gain on your crypto, for example. But they're also obviously thinking about regulating crypto. They're also thinking about, well, do we have our own cryptocurrency? And CBDCs, so central bank digital currencies, are being considered. And I think Biden just announced that they're probably going to do this in the US. The Reserve Bank are thinking about it. I think everywhere, every country's thinking about it. It's probably only a matter of time before we get there. So crypto assets as evidence. Well, it's like anything. It's an asset. It can be stolen. You can have your IP rights attached. So how do you collect this stuff? How do you put it together? And then how do you present it in court? From a legal perspective, in order to get any evidence as evidence in a court proceeding, it has to be admissible. And the way for it to be admissible is it needs to be relevant. If it's not relevant, it won't be admissible. Okay, so again, we've got some case law around that. That's pretty much in Australia the start and end of it. Once it's admitted, and that's a legal question for the judge, the other party can challenge its authenticity. So I guess when we now get into this realm of new tech, how can you and should you challenge the authenticity of some of that evidence? And that question will then go to the trier of fact. That would be before the jury, if there is one, or to be the judge if there is no jury. So some of the challenges are I always say the what, how, who, when, where, and this hasn't really changed. I ran a digital evidence company for about 20 years, and this was always the thing we came back to when we'd sit down with the lawyers and say, what are you collecting? Where are you going with it? What are the pleadings in your matter? And we'd run through these questions. So I guess with blockchain technology, some of the questions might be a little different. So, I think the obvious question is, well, hang on, everything's there. You've got the blockchain, all the transactions are stored on the blockchain. So authentication really shouldn't be an issue. But it could be. We've already had some issues where the consensus has been taken over in effect, and you get a fork off the chain and you go in a whole new direction. That can happen and has happened in the past. We've also had an instance, there was a case in Singapore recently where there was a smart contract and they made a mistake in it, which resulted in one party getting a windfall gain in the value of Bitcoin going up. I think they were exchanging Bitcoin for Ethereum. And one party got a windfall gain, and what they did, they realised their mistake. Could you imagine if you were the programmer? who had written that. It was like, oh, actually, yep, that shouldn't have happened. They reversed the transaction, and then the other party sued for breach of contract. So when the matter was before the court, the defence actually said, well, actually it was a mistake. So remember, for those lawyers in the room, Contract Law 101, if it's a mistake, then the contract's void. The court actually said, well, actually no, we're still relying on the same legal principles. We've got all the elements of a contract there. We've got offer, acceptance, consideration, and intention to create legal relations. Just because you made a mistake in the program doesn't mean there's a mistake to do with, you know, the intention of the parties. It's like any document. If you read it and sign it, well, you're stuck with it. And so, you know, that's an example of a smart contract being flawed and the parties having to live with it. The how. We're dealing probably with some complex tech for the everyday lawyer. Again, I've been working with technology in the law for a long time, and the technology generally needs to be explained, or you've got to have experts that can take the tech, analyse it, and then assist the lawyers in producing what they need to in court. So you probably need some forensic tools, and what we're seeing now with blockchain, for example, there's a whole host of blockchain analysis tools available on the market. Chainalysis is one, and taking that output and making it explainable to a court if you need to. Who? Again, because all the transactions are on the blockchain, everything is there. Originally, it was thought that, you know, people transacting on the blockchain could remain anonymous, but we've seen with things like clustering analysis, heuristics. What that means is if you can analyse the IP addresses, not just IP addresses, but a number of things, including handles. You might remember that Silk Road case where the guy had the Silk Road, which was the dark web website that was selling drugs online. That's how they actually caught him, by tracing IP addresses, using that in combination with some handles and pseudonyms that he was using on the web, and were able to wait. And then I think they got him when he was logging on in a library or somewhere. I saw the movie, so. But there's been some interesting cases. There's Morgan and Liechtenstein in the US. They were actually, they're being prosecuted for money laundering. They got access to a whole bunch of Bitcoin, and they've been trying to get it out into fiat currency. They've even spent it on Walmart and Uber and so on. And obviously everything on the blockchain is tracked. So the investigators were able to trace it to these guys. But I think the reason they were caught was because of the way they did it. They did some pretty silly things and didn't know how to cover their tracks. But also they remained in that jurisdiction. I think if they'd been hackers in China, they may not have been caught. But because they're in that jurisdiction, the investigators were able to track them and find out a bit more about what they were doing. The courts, particularly the English courts, are happy to make orders against people that, you know, are unknown. So we've seen just some examples there of getting interlocutory injunctions, freezing orders, and also getting disclosure orders on virtual currency exchanges. We've also seen, excuse me, service of proceedings on those who we don't know who they are. And this is possible because of the blockchain. We've now had 2 cases, one in England, which was very recent, I think that was only a few weeks ago, of Deloya and persons unknown, and another one in New York. Essentially what they do there is they airdrop a token into the system, and that in effect, or that affects service of those proceedings because it's logged on the blockchain. And so again, the courts are very happy to embrace this, and what they did in the judgment was they compared it to service by fax or email. And the difference there was, they don't really know, is it going to come to the attention of the other person? I think it's easy with blockchain because yes, it can. And then of course the challenges with the where, and this is the big problem. If you can show some nexus to the jurisdiction when you bring your case, then that's great because you don't really have a problem. But we've got problems if you have to sue someone in another jurisdiction. There is a lot of cooperation between Western countries, and I think certainly if you get law enforcement involved, so if you have a civil matter that might be fraud or theft or something like that, bring in law enforcement because they have obviously far greater reaching powers than any civil litigant would have, simply because of the cost too. So if you can piggyback off law enforcement to at least find the people you're after, and then if you need to take civil action on the back of that, that's the best bet. But I don't really have any easy answer to the where because it is an ongoing problem. How am I going for time? Oh, okay, I'll have to just run through this. NFTs as intellectual property. There was an interesting case recently where Rothschild had taken an Hermes handbag and I think they'd covered it in blue fur and then created a NFT out of it and called it a Meta Birkin. It was the Hermes Birkin handbag, and started selling it. And Hermes didn't take too kindly to this and sued for a number of things. And the court said, yep, we can see why you own the intellectual property in that image. And consequently, the NFT was a breach of those intellectual property rights. I don't have much time. I'll just talk quickly about the metaverse. Obviously, there's a whole heap of these new terms, new tech coming in. The legal issues, I think, are those issues that we have been talking about, probably jurisdiction being the biggest one, but also contract, competition, IP, privacy. And with privacy, with the metaverse, arguably you're going to have a lot more personal information such as biometrics, things like that. So things to be aware of. And then I'll just mention governments are looking at regulation of AI. We've already got a draft regulation in Europe, which is this document. There's a lot of discussion about that. How does it go? Does it go where we need to go? And the penalties there can be quite significant. And also in the US, we've now got an Algorithmic Accountability Act, and they're looking at this issue of bias. So Alan talked before about all the great things that AI can do, and I guess the question is, well, the AI can only really work on the data that's inputted. So that whole question of ethics, bias, non-discrimination, and it's good to see that, I guess as expensive it is, I think it's integral to all of this that the ethical considerations remain paramount. And governments can see this, and I think everyone can see this. So we need to make sure that there is no bias in the AI that's happening. So I think that's just a quick overview. Am I done for time?
You've got a few more minutes, but we do have one online question for you.
Okay, great.
If I could read it to you, would you mind?
Sure.
The question is from Ben Gouldson. I am interested in the private international law positions you have experienced and the use of anti-suit injunctions as a way of securing rights in local jurisdictions to the exclusion of claims being brought in overseas jurisdictions. Yeah,
that's an interesting point. So I think, this goes back to the whole, conflict of laws, private laws, and that whole, it's a contest. So if you've got an action to be brought because your rights are being infringed in one jurisdiction and you get, say, a judgment or order, how do you then enforce that in another jurisdiction? I think that depends on the cooperation between governments. And obviously, if you have to take action in another jurisdiction, that's another cost. You need to brief lawyers, you need to get down that path. So I think from a government level, yes, regulation is important and we need to consider that, but I also think the other side of the coin is cooperation, so that, if you do have to bring an action in Australia and you can show that the same infringement or breach or theft or whatever it is happens in another jurisdiction, well, you should be able to easily prosecute that or enforce it in another jurisdiction as well. Does that answer the question? Yeah. But I think, honestly, that is probably the biggest issue and the biggest problem we have with this tech is that jurisdictional issue, and governments really need to get their heads together and address that. Otherwise it becomes problematic. That and identity, who do you sue? I think we're done for time.
One more question. All right, well, Alison, thank you so much.
No problem.